Thank you, everybody, for joining. I'll introduce myself. My name is Usman Mohammed. I am the managing partner of Consensus Legal Law Firm. Consensus Legal focuses on commercial sales, leasing, and financing transactions. You're here because you probably use the AIR CRE contracts. I think we can all agree that these are extremely well-drafted contracts. It makes transactions easier and quicker when you use these contracts. And in my opinion, nationwide, these are the best commercial real estate contracts out there. They are now available nationwide in about 48 states approximately, getting closer to hitting all 50 probably pretty soon. A couple disclaimers. AIR Forms Practitioner is not affiliated with or sponsored by AIR CRE. I'm not providing legal advice during these webinars. It is for education and discussion purposes. So for today's 20-minute webinar, we'll focus on 3 key hazardous substances concepts in the AIR CRE leases. Feel free to ask questions in the chat box along the way. I may be able to address some of them during the webinar itself, but if not, I'll be staying for about 20 minutes after the webinar for Q&A. Okay, so I will share my screen and I'm going to share the AIR single tenant net lease. And so what I've opened it up to, this is paragraph 6.2a of the AIR CRE lease. This is the same paragraph in the vast majority, in all the regular AIR CRE leases. And the first key concept that I want to discuss is the general rule of what hazardous substances lessee is permitted to bring onto the premises. And the general rule is here in paragraph 6.2a. Lessee may use any ordinary and customary materials reasonably required to be used in the normal course of the agreed use. So the general rule is on page 1, however you fill out the agreed use, the ordinary and customary materials reasonably required in the normal course of that agreed use, the general rule is that they are permitted to be used by the lessee. And that makes the agreed use and how you fill out the agreed use very important, because sometimes we'll see a very broad agreed use where it'll say something like warehousing, office uses, and all other legal uses. When you have that broad of an agreed use, that gives the opening for lessee to use all sorts of hazardous substances. So I would suggest, to be particular and careful when you complete that agreed use. So that's the general rule, but there are limitations. Lessee can't just use any hazardous substance in the normal course of its agreed use. There are 3 specific conditions for lessee. Number 1, lessee has to comply with all applicable requirements. Applicable requirements are applicable law and matters of record, such as, CC&Rs. The second condition is that lessee's use of the hazardous substances does not constitute a reportable use. We'll get into the details of what a reportable use are, but that's the second condition. I'll just mention that for now. And then the third condition is that the lessee's hazardous substances do not expose the premises or neighboring property to a meaningful risk of contamination, etc. So we have the general rule and then the 3 conditions. Okay. Now let's get into this condition number 2 a little more. What is a reportable use under the AIR CRE lease? And there are 3 items that constitute a reportable use. The first one is the installation of a storage tank. So if the lessee is installing an above or below ground storage tank, it is required to obtain lessor's consent because it's a reportable use. The second reportable use is the generation, possession, storage, use, transportation, or disposal of a hazardous substance that requires a permit from or with respect to which a report, notice, registration, or business plan is required to be filed with any governmental authority. So if lessee needs a permit from a governmental authority, if it needs to file a report with a governmental authority, it constitutes a reportable use, and it therefore requires lessor's prior consent. And the third item that constitutes a reportable use is the presence of a hazardous substance with respect to which any applicable requirements requires that a notice be given to persons entering or occupying the premises or neighboring properties. So if lessee is using a chemical that requires, a notice as you're entering the premises, that would be a reportable use that requires lessor's prior consent. And that prior consent requirement is right here above. Lessee shall not engage in any activity in or on the premises which constitutes a reportable use of hazardous substances without the express prior consent of lessor. Okay, so I know that's a lot of information. So just a quick recap. The general rule, lessee may use any ordinary and customary materials reasonably required to be used in the normal course of the agreed use. Filling out that agreed use is important with respect to the hazardous substances provisions. There's 3 conditions for lessee. It has to comply with the applicable requirements. Its use cannot constitute a reportable use, and it cannot expose the premises to meaningful risk of contamination, etc. Okay, so let's say it does constitute a reportable use. Lessee is engaging in an activity that constitutes a reportable use. As noted here, prior written consent of lessor is required, but it doesn't have to be a yes or no from lessor. Lessor can condition its consent. It can say, yes, I'll allow it, but it's conditioned on certain things. And the AIR lease specifically gets into some conditions at the bottom of 6.2a. Lessor may condition its consent to any reportable use upon receiving additional assurances as lessor reasonably deems necessary to protect itself, the public, the premises, and or the environment against damage, contamination, etc.
But no, I picked up the lights for Jose.
And so it can specifically condition its consent on these items, and it references lessor can require the installation of protective modifications such as concrete encasements. It can also condition its consent, this is an important one, to increasing the security deposit. So it doesn't have to be a yes or no answer. So I will pause there. I'm just going to check the chat box. Question is asked, would lessor consent constitute lessor liability? Good question, Jen. We're going to get into liability, remediation, and indemnification in the next two concepts. So that's a good segue. Thank you so much for that question. Okay, so that's the first key concept, hazardous substance concept in the AIR CRE leases. We're going to move to the second concept. The second concept is lessee's remediation and indemnification obligations. So let's say lessee brings hazardous substances onto the premises and something happens. What are lessee's remediation and indemnification obligations under the AIR CRE lease? So under 6.2C, if there is a spill or release, for example, lessee must, at lessee's expense, comply with all applicable requirements, comply with the law, for the cleanup of any contamination of, and for the maintenance, security, and or monitoring of the premises or neighboring properties. And this is the key phrase here, that was caused or materially contributed to by lessee, or pertaining to or involving any hazardous substance brought onto the premises during the term of the lease by or for lessee, and importantly here, or any third party. So that is a key provision. Lessee is not responsible just for hazardous substances brought onto the premises by or for lessee. It's responsible for hazardous substances that may be spilled or released by any third party. And the concept here and the rationale here is that lessor is not on the premises on a daily basis. Lessee is on the premises, it's operating in the premises, and it is the lessee that should be securing the premises, making sure that only the appropriate people are entering the premises, etc. So under the AIR CRE lease, lessee is responsible for hazardous substances spilled or released by any third party. Now, I'll give tip number 2 here is when you define the premises, sometimes we see for single tenant leases, we see the premises is defined as just the building. And then in other circumstances, we see the premises is defined as the property, the entire property on which the building is situated. Now, if the premises is only defined as the building and a third party spills or releases hazardous substances on the property but outside of the building, then arguably, because it's not in the premises, lessee is arguably not responsible under the AIR CRE lease. So there is significant importance in terms of how you define the premises in a single tenant lease in particular. Lessee's indemnification obligation is in 6.2D. Lessee shall indemnify, defend, and hold lessor harmless arising out of or involving any hazardous substance brought onto the premises by or for lessee. And once again, the same concept, or any third party. So the indemnification obligation applies to hazardous substances brought onto the premises by third parties. So that is the second key concept about hazardous substances. We have a few more minutes, and I have a third concept that I wanted to discuss, and then we'll go into the Q&A. So the third concept is lessor's indemnification obligation. So it's not just lessee that has an indemnification obligation. Under certain circumstances, lessor is required to indemnify lessee for certain hazardous substances. So what are those hazardous substances that lessor is required to indemnify lessee for? It's for hazardous which existed on the premises prior to lessee's occupancy. That's the first category where lessor's indemnification obligation applies. And the second is for hazardous substances which are caused by the gross negligence or willful misconduct of lessor, its agents, or employees. So these two categories of lessor's indemnification obligations for hazardous substances is market for the most part. In most attorney drafted leases, or not most, but many, lessor will have an indemnification obligation that is similar to this. Sometimes when lessee has leverage, it will modify the second category so that it's not just hazardous substances which are caused by the gross negligence or willful misconduct of lessor, but this word gross may be deleted, so it's negligence or willful misconduct of lessor. Or sometimes it'll be modified to say for any hazardous substances which are brought onto the premises, etc., by lessor without the necessity of any negligence or willful misconduct. So that is the third key concept that I wanted to discuss during this webinar. And now I will open it up for Q&A. And let me check the chat box as well. Feel free to post a message in the chat box for a question. Jin, did I answer your question? Would lessor consent constitute lessor liability? I guess I didn't. So by consenting to a reportable use, for example, it doesn't change the lessee remediation and lessee indemnification obligations. And it doesn't change the lessor indemnification obligations. So lessee would still be responsible under pursuant to 6.2 C and D. Don asks, what about hazmat dropped off by an unknown party onto the property? Yeah, that's a great question. And that's where we get into this third party concept. So, and let me share the screen again. So, yeah, with this third party concept, even if it's whether it's a known party or an unknown party, it doesn't matter. Lessee is responsible. And I think Ted notes that seems onerous. Yeah, I think some people do believe it's a tough responsibility for the lessee, but the rationale is that the lessor isn't in a position to secure the premises, to make sure only responsible people are coming in and out of the premises, and that's why that responsibility is on lessee. Ted asks, tenants are more and more asking for landlord indemnity for any hazmat placed on the shopping center by any parties other than tenant and its agents. So, yeah, in the shopping center context, or even if it's an office building or industrial building, if you're talking about a multi-tenant scenario and there are hazardous substances in common areas, then yes, frequently tenants will ask for some type of um, indemnification for those situations. That's right. Tim asks, thanks for joining, Tim. Nice to see your name. How would you handle a request to exclude any migration to the premises during the term through no action or fault by lessee, or caused by unrelated third parties not hired or controlled by lessee? That's a very good question, Tim. And the AIR CRE lease actually deals with migration of hazardous substances to the premises. I didn't go over it specifically because of a limitation of time, but let me just pull that up. So yeah, it's 6.2D. So this is in the lessee indemnification provision. Lessee has these indemnification obligations to lessor, but the AIR CRE lease clarifies that provided, however, that lessee shall have no liability under this lease with respect to underground migration of any hazardous substance under the premises from adjacent properties not caused or contributed to by lessee. So good question. And under the indemnification provision of lessee's indemnification obligation does not apply in that scenario.
Thank you.
I'm sorry, did you mention something, Tim? Did you have a follow-up?
Thank you. Thank you.
Oh, of course, yeah.
Okay.
John asks, how about owner known hazardous contamination? Yeah, so if the lessor knows about hazardous substances, and uh, and lessee, comes into the premises, lessor's indemnification obligation would apply. Number one, lessor may have disclosure obligations, but even aside from that, under paragraph 6.2E of the AIR CRE lease, lessor is obligated to indemnify lessee and hold lessee harmless from and against any and all environmental damages, including the cost of remediation, which result from hazardous substances which existed on the premises prior to lessee's occupancy. So lessor's indemnification obligation would apply in that scenario. Vinil asks, should tenants leasing industrial or auto-related spaces conduct a phase 1, phase 2 environmental study prior to signing the lease? Very good question. And I would leave that up to your environmental consultant. That's could very well be an appropriate and prudent thing to do. You have to think about a whole host of scenarios. Lessor does have an indemnification obligation, but it's probably appropriate in that scenario to consult an environmental specialist. Ted asks, landlords prefer for the tenant to pursue the responsible parties rather than just, such as another tenant, rather than just making this a landlord indemnity obligation. Could you clarify your question, Ted? I'm not sure if I'm understanding that. David asks, lessee would need to go through the city fire department and all other jurisdictions in writing. I'm not sure if I understand that, David. Yeah, under the reportable use concept, if if there needs to be a report or a filing with a governmental authority, or if the approval of a governmental authority is required, it constitutes a reportable use and lessor's consent is required. Jen says, would the waiver of subrogation apply? That applies, yeah, when there's an insurance claim. Yeah, the waiver of subrogation could apply in the insurance if there's an insurance claim. Okay, I think. Here's another question by Isabel. Getting back to your comment regarding description of premises, building versus the property. What is your suggestion in addition to the address and approximate square footage of the building? Good practical question there, Isabel. So if you want to ensure that it is clear that the premises is described as the entire property, as opposed to a scenario where it might be ambiguous as to whether the premises is the building or the property. Typically, how we do it is we describe the premises as X acres of land or X square feet of land on which a building of Y square feet is situated. That's how we frequently describe it when we want to ensure that the premises is the entire property rather than just a building. Good question. If you have any follow-up questions, Greg or anyone else, feel free to reach out to me by email. Thank you, everybody, for your time and attention. It's so nice seeing everybody, and look forward to hopefully the next webinar next month. Thank you, everybody.